Good afternoon, everyone, and welcome to the J&J Consulting Services Investor Call. Today is March 16th, 2026. It's approximately 1 p.m. Pacific Time. Before we get started, I do want to give my typical disclaimer that anything said in this call should not be construed as legal or accounting advice. If you need good legal or accounting advice, I recommend that you reach out to a competent attorney or tax accountant. Just going to get started by going ahead and jumping directly into the investor questions. And if anybody has any further questions that aren't answered, feel free to type them into the chat and we will attempt to answer them if we have opportunity to do so. So the first question is, how much money was dissipated through the J&J Consulting case? The total number, the total amount invested in the case now is just over $519 million. Not all of that was money that was wasted. Some of that was returned to investors and other such payments. Next question has to do with the amount of fees being charged for the work being done and why things are so expensive. The biggest reason why things have been expensive in this case is a lack of documents and a lack of accounting in the case. Oftentimes when we get involved in these cases, we know who the investors are and in some instances know how much they've invested and how much they received back. Unfortunately, in this case, we had none of that information available to us. And so we were forced to subpoena banks in order to get documents and other parties in order to get an understanding and completely recreate the accounting of what was going on in the business. Accounting that you would typically see in any business was not available to us here. So we were forced to recreate that from scratch, including all money in and money out, plus some asset transfers, as well as transfers of other goods and services. So it took a significant amount of time to be able to get all that material together, then put it back together and create an accounting out of it that would allow us to figure out how much money was brought in by investors, how much money was returned to investors, and then where all the other money was spent. Next question is, do you have any information on managing personal tax returns regarding this investment and losses for people? So in the case, we don't yet know what the total return will be, so it's going to be impossible to determine what your loss is. However, I would recommend reaching out to a competent tax accountant in order to see if there are potential solutions for you as it comes to dealing with the IRS. Next question is, when do you expect to close out the case? We are working through the case in the various different steps. We are just about to finish up the claims process, and then we'll be recommending a distribution. And then the primary piece to complete before we can wrap up the case is going to be dealing with the third-party litigation against net winning investors, against promoters, as well as other third parties who receive money that they were not otherwise entitled to. And depending on how long that process takes, that will push out the end of the case. It could be that the case is closed in 2027, but it's going to be impossible to say until we know how long some of that litigation will take. And next question is, how do we report inaccurate findings? If that question is inquiring about the amount of money that we believe that you received or that you put in, if you have specific questions related to that accounting, you should reach out to our office directly, and we're happy to work through those issues with you. We've already done so with dozens and dozens of investors and are happy to continue to do so if you have specific questions. Next question is, how do you correct names as an investor? If you need your names corrected, you'll just need to reach out to us. We may ask you for some documentation, and then we will work with you to get any name change done that needs to be done. Next group of questions has to do with distribution. So the first question is, have you submitted a distribution plan to the court? No, we have not submitted a distribution plan yet. We have to finish the claims process first before we can do a distribution process. The good news is we do anticipate that the claims motion will be filed with the court in the first or second week of April. It has taken a little bit longer than we had hoped it would take to complete that process, but unfortunately, we have discovered some cash investments as well as some pooled investments that we've had to work to break apart. And so there are, out of all the claims that received, the 969 claims, there are still just a handful that we're working on to push to completion. And we'll do a final quality control audit on them, and then we'll be filing that in like I said, the first or second week of April. Next question is, are you able to get the court's approval for a distribution formula before we have the money for Wells Fargo? Yes. So typically what we'll do is a distribution process that allows us to distribute money at the time at which we feel it justifies it. There's enough money to justify doing a distribution. So the Wells Fargo question is a good question because we don't know exactly when that will wrap up yet. The hope is that it will wrap up in time that we can get it involved in the first distribution, and we'd probably even be willing to wait a short period of time to make sure that it gets included in the first distribution. However, if we think there's going to be any significant delay in being able to do that, we will do a distribution without it. And then, as I stated, once the court gives us an authorization to do a distribution plan, then we can do subsequent distributions without further order and can get those out fairly quickly. Next question. What is the likely timing and amount of the first distribution? As I stated, our goal is to file the claims motion in the first or second week of April. The distribution motion would be filed very quickly on its heels. And so that is the plan, is to get that on file, as quickly as possible, as soon as the claims are dealt with. So we have to file the motion with the court, and then the court has to hear that motion and decide how they're going to deal with that. Let's see. So the next question after that is how will disbursements start being made to investors? We have not made a final determination yet on how distributions will be paid, but it's likely that they will be paid via check that will be sent to the address on the claims form, unless you have an update, at which obviously you're going to want to reach out to us. Next question is, how will the settlement be divided? Should it be awarded by the court? So typically distributions are done on a pro rata basis, meaning everyone will get the same percentage of their allowed claim. So if you have 100,000, this is just a complete hypothetical, but if you have a $100,000 claim and there's a 25% distribution authorized, that would mean that you would get $25,000 as part of that first distribution. Next question is, can a check or a payment be made directly to an IRA bank account or an IRA rollover? We are able to send checks to custodians, and so if that is what you need to have done in order to keep your retirement account current, then go ahead and reach out to us, and we will go ahead and make sure that we can edit that check to make sure it gets sent the right way. Next question is, if the Wells Fargo settlement funds are to be paid out about the same time, will you wait to distribute the funds included in the settlement? Like I said, if it's going to be a short period of time, then yes, we would likely wait to try to do the two distributions together. But if not, we could do a distribution, and then there would be a short period of time before we would do a second distribution. Next question is, what is the total dollar amount of the approved claims? As I stated, there's still a handful of claims that have not been completed yet. But as it sits today, it's just over $246 million in claims that we are going to recommend that the court approve. Next question, what is the dollar figure that you have in cash, and how much of that are you going to reserve? So currently we have over $70 million in cash. The amount that will be reserved is going to be based on the total amount of expenses we anticipate that the estate will have, plus any potential for tax liability that would need to be reserved for. So that has not yet been determined, but that will be part of the claims motion that will be filed. And so that information will be publicly available. Yeah, so if you have any questions on that, again, you can reach out to us. Will there be more than one distribution? Yes, there will be more than one distribution. It's likely in most of these cases there are 2 or 3 distributions in the cases, and sometimes have been even more, depending on the breakdown of how the money comes in and at what point it can be distributed. Is the claims audit complete? And if so, when was it completed? If not, why has it taken longer than anticipated in our December call? It has taken a little bit longer than we anticipated because of the fact that we are discovering new things all the time that did not show up in the records. As I stated, there were some cash investments, there was some merchandise exchange for investments, as well as a number of claims that were pooled together that have to get broken apart in order to do that. So, that being said, it did end up delaying us slightly being able to work through those issues in order to come to a resolution on them. So, the goal is to try to prevent any type of objection in the case when it comes to filing the claims motion. So we try to deal with all those issues up front. That way it reduces the likelihood of an objection and can speed up the process as we go through it. Next question has to do with defendants and parties. Could you please update the group on the legal steps that have been taken to hold those responsible for the Ponzi scheme? So as a reminder, this case that we're discussing right now is the SEC's case against the defendants, and this is a civil action only, and so they're going to be held civilly responsible for it, which means the payment of or disgorgement of enrichment plus potential penalties. As far as the criminal side goes, that is a completely separate action that would be brought by the Department of Justice. What became of the lawsuit against Beasley and Judd? So the lawsuit against all the defendants is still ongoing with the SEC. It is currently in a stayed status, although that does not affect the receivership itself. It just means that the SEC isn't coming up with finalized settlements at this point with defendants or working with defendants as to the guilt or innocence in the civil case. That will be opened back up once the criminal side has determined what they're going to do in the case. Are the lesser defendants liable for additional restitution since they are participants? So all the defendants in the case will have their case either tried or settled, and they will be responsible for disgorgement of ill-gotten gains as well as potential penalties. The next question is, will defendants receive jail time? The only defendant that has so far been criminally charged is Matthew Beasley. He has pled guilty, and there is a sentencing hearing upcoming in a few weeks regarding that, and he will continue to stay in prison throughout the term that is decided by the court at that point. Next group of questions has to do with litigation and third parties. First question is, what is the status of the Wells Fargo litigation? What are the terms under discussion? So on October 1st of 2025, at our third mediation session that we held over a couple-year period of time, I along with the class plaintiffs in the class action case, made a substantial progress towards settling that or coming to an agreement with Wells Fargo. We have a binding term sheet with them. However, due to the mediation confidentiality, the settlement is confidential until we can work with class counsel and Wells Fargo on a formal settlement agreement, which we have been working on since October 1st. Any settlements can be contingent upon the court's approval, so the judge will have to approve it. The terms are going to be disclosed when the settlement is finalized and filed in court. But meanwhile, the litigation cases stayed while we work through this deal. Unfortunately, this is a complicated process because of the fact that there are two cases going on at the same time. There's the case that I have filed plus the case with the class, and we'll talk about kind of what that means here. So the next question is, how many litigants are involved in the action? So technically there's two. There's my lawsuit, the receiver's lawsuit, representing the investors, and then the separate class action. And there's 8 individuals that are representing that class. However, any money that is recovered as a result of that is going to be paid to the receivership estate and will be distributed out to all investors with approved claims. Are the attorneys taking a percentage of the money recovered from Wells Fargo, or is it based on an hourly rate? The agreement was a percentage of the recovery. It was a discounted percentage of the recovery, but that's ultimately going to be up to the court's discretion as to whether or not that's approved and what that percentage will be. Next question is, how effective is Wells Fargo in dragging out the process? So as we said, a settlement has been reached, and we are working together on coming up with a finalized resolution. It is complicated by the fact that there are 2 lawsuits and that each one has its own requirements as to how it gets dealt with. And so we are working through that issue and hope to have a resolution here very, very shortly. Was the settlement with Wells Fargo finalized, and what was the total dollar amount? We do have a dollar amount that has been tentatively agreed to, but the terms have to be finished before it gets filed, and the information can't be public until that time. Ultimately, it'll be up to the court to decide whether or not to approve that settlement. When will we know? When will we know about the Wells Fargo settlement? Drafts of the settlement agreement have been circulated between the parties multiple times, and we've been negotiating the terms. Once the final agreement is signed, both myself and the class plaintiffs will move for court order approving the settlement, and then notice will be sent to all interested parties at that point. At that point, it will become public. It will be posted on our website, and you will receive an email letting you know that that information is available. Next question. If somebody has a current banking relationship with Wells Fargo, will any settlement reached on the investor's behalf prohibit them from filing any future claims separate and apart from this matter? No, there will not be a prohibition that would prohibit an investor from suing them for some other act in the future. Is the 85 million of third-party litigation that's under the asset category in Exhibit E of the quarterly report the amount that's agreed to with Wells Fargo? The answer is no. A dollar amount has been agreed to, and the settlement amount has to be finalized before it can be made public. But that figure does not represent the Wells Fargo settlement. Explain the Grigsby case. How was he involved? How much money was lost through him? What was the fraudulent transfer, and can it be recovered? So the Grigsby case, so Aaron Grigsby was an attorney that represented both Matt Beasley and Paula Beasley at one time. We did sue him for recovery of funds that he had spent. The court granted us an award along with attorney's fees, and then Mr. Grigsby filed for bankruptcy. We have been working with the bankruptcy estate to attempt to recover funds, and do hope that there will be a recovery there. In total, it's over $500,000 that we're trying to recover in that case. The next group of questions has to do with assets, and so we'll get to those here. So what is the transaction on the register for exhibit in the report dated 12/31/2025? The incoming wire for $1,338,000. So that was a settlement with a net winning investor who agreed to return the funds to the receiver, and hope to do so before the end of the calendar year. So that's what that deposit was. Are there any remaining assets to be collected, and what is the estimated value? Yes, there are a number of assets that are left to be collected, and we will be collecting those soon. Those will go towards the disgorgement and restitution figures of the defendants. We believe that there are tens of millions of dollars of assets still remaining to be collected and sold, and we'll be getting that process very soon. Is there still real estate that can be sold? Yes, some of those assets are real estate. Are defendants hiding any assets? Obviously, if they're hiding them, we may or may not know about them. If you know or have any information related to assets you believe may be being hid, I would strongly encourage you to reach out to us and have a conversation with us. We're always happy to get that type of information in the hopes that maybe it is something we don't know about and can go after. What other banks has the receiver considered a case against? Are there other open cases? There are not currently other open cases. However, we are considering litigation against other financial institutions as well as other parties, and those will become public when they're filed. But at this point, we don't have any information as to who those targets might be. Next group of questions has to do with clawbacks. Some of the investors received net positive from this fraud. Will we be going after those funds to make the rest of us whole? Yes, we have begun the process of filing litigation. In fact, just last week, we filed a motion with the court requesting permission to be able to sue certain parties who obtained net winnings or commissions as a result of selling the investment in the J&J entities. And so we have asked permission of the court to be able to file suits against them, and anticipate having a resolution on that by the end of this month. Will a list of available net positive investors be made available? There will be a list that is attached to the litigation that we filed as to who we are going to file against. But the second part of that question has to do with whether or not the individual investors will be able to go after them. And the answer is no currently, because there is a stay of litigation in place that would prohibit anybody else from suing them. But as I said, we are actively working on recovering those funds from them ourselves for distribution to all the parties. What is the status of recovering funds from the net winners? Have any of them recovered or have any of them returned funds to date, and how much? What is the total amount we're trying to recover? So the first question is, we've requested permission of the court to be able to file the suits. We are just waiting on the court to grant that. and having them return funds to date, yes, we've received, I believe, 5 total return funds, approximately $2 million. But the total amount that we're seeking to recover is around $58 million that we hope to get back from these parties. Are promoters being required to pay back? Yeah, the answer is yes. We are also going after promoters who made commissions in this, and we'll be seeking to get those recovered as well. The last question, sorry, in that group is if clawback per investor is under $1 million, will those be settled or litigated? We always attempt to try to settle everything before we resort to litigation. Litigation only happens when we can't get parties to agree and to return funds. As to what the cutoff is, that's done on a cost. We look at it kind of on a cost benefit analysis. We look at the amount of money that we're seeking to get returned and look at the cost to try to get it returned and make sure that it makes sense to go ahead and go after it. And so that's where we're at with that. That is the last of the investor questions that came in. But before we do that, I am going to just take a quick look here to see if there's any questions in here to determine. First question is, will you be reporting distributions sent to each investor to the IRS? Our goal is not to report that information because they are return of principal investments, so that is not typically taxable. However, we have from time to time been required to provide tax ID numbers for people that we have paid. But again, it's our hope that we won't be required to do that in this case, since we do believe that they are a return of principal. So can you give an estimate on when you think it will, of when we think that the court will approve the distribution plan? Again, it will be filed in April, and as to what date the court approves that, that's ultimately up to the court. It's very likely that it would take, depending on exactly when it gets filed, but it's likely it'd either be the end of April or sometime in May before the court would hear it. But again, that is ultimately up to the court and whether or not there's any objections or anything else that has to be done in that process. The next question just has to do with Wells Fargo. We already talked about that. I mentioned a short amount of time between, if we have a settlement that's been filed with the court and we're close to the objection period or when the objection period would run, it's likely that we would want to then wait because it could be as quick as a couple weeks, and as long as as the court takes. But if we think it's going to be a short period of time, 2 to 4 weeks, we would definitely wait on those funds in order to distribute those all at one time. If we think it's going to be longer than that, like I said, we will do a distribution of the funds we have available at that time. Let's see. A question about clawback actions and bankruptcy. That unfortunately is a legal question that I unfortunately cannot answer in the chat. Somebody has a question about a specific individual dealing with Horizon Trust. I can tell you that individual does have knowledge of this investment, but outside of that, I don't know what the question is trying to ask there. Do we have a guesstimate of the percentage distribution before lawsuits? Not yet, because we have not yet determined, or the SEC has not yet determined exactly how much they're going to be required defendants to be disgorged and final any kind of penalties that are associated with it. And so we don't have that number yet. We continue to work as hard as we can to increase the amount of money that we're collecting, and we'll continue to do so. Let's see here. Next question. When's the next meeting with Wells Fargo? So our counsel, both our counsel and class counsel, are meeting with them regularly to go through the finalized deal and having to come up with the terms. Like I said, it's a little complicated because there's 2 different courts involved, and trying to make sure that it gets make sure that what we do is complies with both of the courts. Already answered the question about Wells Fargo and Exhibit. When can we realistically expect the first distribution? I mean, there's some hope on our part that it could be late April, but honestly, given how long it takes to get through the legal process, it's more likely to be in May, and could even be later if there's objections or if there's something that happens that delays that. We want to get it out as quickly as possible, and so we're going to push on our end, like I said, to get it filed right on the heels of the claims motion. And then it's just ultimately up to the court and what legal process might happen. Let me see here. I'm just going through some more of these questions here to make sure that there aren't anything. Um, it sounds like we haven't collected, we've actually collected a couple $1 million since the last meeting, and that number will continue to grow, like I said, very, very quickly. The one thing we were doing, since we were doing a forensic accounting, we wanted to make sure we understood the numbers completely as to what people owe, because when we go after people, we're doing it and we're signing a settlement agreement, so we want to make sure we understand everything that they owe. And that's exactly what we're doing. Let's see, distributions made to investors whole. There's some missing principal. So distributions are made on a money in, money out basis. So you take the total amount you invested minus the total amount you'd previously gotten back, and that tells you what your claim is likely to be approved for. And then again, although the final decision has not been made, typically in these cases, it will be a pro rata distribution, meaning everyone will get the same percentage of their claim amount paid to them. Let's see, questions about the cash and the total amount in clawbacks. We are not going to wait on clawbacks before we do a first distribution, because we're going to be doing clawbacks, over the next 12 to 18 months minimum. And so we will continue to do that, and that will not be a holdup for this first distribution at all. Once distributions are released, will 1099 be issued? It's unlikely that we will actually issue you a 1099 ever, because again, the money that we are returning is a return of principal, not interest. And so these are not profits, and therefore it's unlikely that we will ever give out a 1099 in this case. Can you say if the Wells Fargo settlement is 8 figures or 9 figures? I cannot say what the Wells Fargo settlement is at all. I don't want to risk being the party responsible for breaching that, because that could cause financial harm to investors, and I don't want to put us in that position. Last meeting, you said the amount of agreement with Wells Fargo was significant. Do you still stand by that? Yes, I still stand by the fact that it is significant, but I will not assign a monetary value to that. Again, ultimately, it's up to the court to decide whether or not they think that the amount that we're settling for is appropriate given the strength of our case and the risk of litigation. Does the Wells Fargo settlement include litigation costs? Again, I cannot talk about the terms of the Wells Fargo settlement at this point. I wish I could. I was hoping that we would have a finalized agreement by now, but I do understand the complexities involved in it. And so it's unfortunate it's taking longer than we would have liked, but we are pushing as hard as we can to get it done, because I would love nothing more than to include that money in this first distribution. Next question is, so the max total of claims is 246 million. As I stated, this is actually as of last Thursday, the total amount of claims before those escalated claims is approximately $246.3 million. But there are some outstanding claims that could cause that to go up or down slightly. But we do anticipate that the final number is going to be somewhere in that neighborhood, plus or minus 1 or 2%. We're not talking about a significant difference. On the first distribution percentage of the net loss, or what percentage? Again, that number is not available yet, because it depends on how much money is collected between now and then. We're going to request the court basically allow us to pay out everything we can, less the holdbacks that we need to hold on to for administrative expenses and any potential tax issues that could arise. Should we have heard from you if we made a claim? If you received a determination letter and you signed that determination letter, then it's very unlikely you would have needed to hear from us unless we had some question about it. If you have questions, I would recommend you reach out to us right away. That way we have an opportunity to make sure that something did not happen in the process. So I would recommend reaching out to us just to verify. Send us a quick email, and we're happy to look at it and just say, yes, we received your claim, everything's okay. Once the court approves the distribution, how long does it take your firm to issue checks? Typically, checks would go out within 7 to 10 business days at the longest. There are a number of checks that will be going out in this case, so we want to obviously make sure that process is done correctly. But it only takes a couple days to load the distribution into the system, and then we will then print those checks and mail them out at that point, and so that takes very little time. Like I said, 7 to 10 days is a good estimate of what we think that'll take. Now, keeping in mind, of course, if the court changes the distribution in any way, then we will have to tweak the system to allow for that. But again, we're talking about a couple days, not an extended period of time. The next question has to do with $85 million. What does that reference? It references a combination of things, and it is just an estimate. Keeping in mind, of course, that estimate will change on a daily basis based on the number of factors, including litigation, additional assets that we find that we think can be recovered, and those types of things. I was told that defendants can keep their houses they're currently living in. We have allowed some defendants to stay in some of the homes. To the extent that they still owe money and don't have the cash available, then we will be seeking to recover those assets as well as any other assets that we can recover in order to pay off the debt that is owed to investors. What confidence do you have that losers will be made whole within 2 to 3 distributions? Again, because we're in litigation, we don't yet know exactly how much money we will recover. So I cannot say with any certainty whatsoever that investors will be made whole at all. And in fact, in receivership cases, it's fairly uncommon for investors to be made 100% whole because some money is lost to ways that cannot be recovered. For example, vacations, weddings, money that's just spent in ways that just cannot, we absolutely cannot go back after because it's been used up. But we do always look for additional avenues of ways to be able to collect that, and we will do so here. Should we expect another meeting before the first distribution? Again, I would hope not. I would hope that we will actually have the first distribution out before we have the next meeting in approximately 3 months. And so, barring anything, catastrophic or any major delays, we should not be having another one of these meetings until after we do that first distribution. You mentioned holdbacks a few times. Do you have any idea how much you're anticipating in holdbacks? 5 million, 10 million, 15 million? So at the time that we're preparing a distribution, then we will look to see how much needs to be held back. I am working on getting an estimate from my tax preparers to see if we think there'll be any tax liability owed. Part of that has to do with working with defendants and their taxes, and so we are doing some of that as well concurrently with this. But we don't yet know the total amount that we will be looking to withhold in that case. Can you give an estimate percentage range of what we'll see in the first distribution? I can't because it depends on if it just includes the cash we currently have on hand or if it includes part of the Wells Fargo money. As I said, we're settling with winning investors on an almost daily basis, so that there's money coming in there as well. Not to mention we are about to file litigation against them, and I think that we'll see a number of those investors look to settle with us prior to getting those suits filed. So we'll continue to do that. Will the receivership income be made public? It is. That information is public and is available in our reports. Hypothetically, if you recovered 100% of what is owed to investors, what percentage would be held back to pay lawyers assigned to this? So with the exception of the holdback that's required by the court, the attorneys in this case are paid as they earn it and as the fees are filed. So there would not be an additional holdback in that case. So it seems if 249 of 519 has been collected, that's 47%. Wouldn't the disbursement be in that range? So we have not collected, those two numbers are actually incorrect numbers to be using. So 519 million was the total amount of money raised in the case, but the total amount that is still owed to investors is approximately $246 million. And so it would be the amount collected divided by 246 million. The next question has to do with the Wells Fargo numbers. Again, I can't answer that question because I can't disclose anything that would lead to any of the terms of the settlement agreement with Wells Fargo. But I do want to remind people of the contact information. If you have questions, we recommend that you email us. The email address is contact@jjconsulting-receivership.com. Again, that's contact@jjconsulting-receivership.com. The phone number is area code 702-832-2299. Again, 702-832-2299. And finally, if you have not already, we recommend that you go to our website, jjconsulting-receivership.com. Again, that's jjconsulting-receivership.com. There you can register to get notice as well as see any documents that have been recently filed. I will answer the last question that came in real quick, and that is when do we expect the Wells Fargo terms to be finalized? We have sent back some changes that we think needed to be made to the agreement. Like I said, we've been going back and forth for months now. I do think that we're very close and do hope to get that filed very, very soon. Like I said, we've worked through some of the logistical issues that we had, and so I do think we're close and really hope to get this done soon so we can wrap it up, get the payment, and then get that money out to investors as part of that first distribution. So thank you all for joining the call. If you have any questions, please do reach out to us. We are doing everything we can to get this money into your hands as quickly as possible. I know it's a very slow process and it's very frustrating. I apologize that you guys are stuck in this situation. It's very unfortunate. And the fact that we had no records made it even more so. But we are doing everything we can to fix the problems that were created by others and hope that you continue to give us the patience necessary to do that. And again, if you have questions, please do reach out. We're always happy to discuss. Thank you very much.